You are watching Sorainen Public Procurement Academy. Stay tuned.
Hi, my name is Kadri, and in this presentation I'm going to talk a little bit about what happens after you have submitted a tender bid in Estonian public procurement. So, what are the topics that I will cover today? I will talk a bit about that when you have already submitted your tender bid and the contracting authority starts asking questions, how to answer them and what to know when answering the contracting authority's questions. As next, we will discuss the situation where you have forgot to submit a document or you have submitted incomplete data, what happens then, how to react when the contracting authority again is asking about it. Then moving on to the business secret part, how much in the Estonian public procurement is public and do you need to worry about the contracting authority publicizing your business secret. And then as for last, I will cover the issue of time limits, how much time is needed or is statutory for the contracting authority to spend on the public procurement procedure in Estonia. And as last, we will cover a bit about the decisions the contracting authority makes during the public procurement procedure. And throughout the whole presentation, on the slides there is a mark CA. It means that the contracting authority or entity, the one who is conducting the public procurement in Estonia. So when you look at the presentation and see it on the slides, then you know what it means. To start off, I'll talk about the contracting authority's questions. When contracting authority starts asking questions, how to be ready for that or what it means. So first of all, the contracting authority is the one who is responsible for making the public procurement or conducting it and making it in a legal way. Meaning that the contracting authority is the one who ensures that everything is done as the law or the public procurement documents require. And there are two cases where the contracting authority might need to ask questions, and in a very broad sense you can divide them in two categories. One is when the contracting authority is obliged to ask questions, and the second one is when the contracting authority is allowed to ask questions. It seems rather self-explanatory, but the substance might be a bit tricky, so I'll cover both. First of all, when is the contracting authority obliged to ask the submission of extra data, some documentation or whatever answers they might require? It's in the case where the law requires it, and it is so when the contracting authority has a suspicion that the tender price is abnormally low. In that case, they are required to start a review procedure, meaning that you will receive some questions about your price. And for example, the contracting authority is obliged to control in substance for the successful tenderer whether their qualifications and the absence of the exclusion grounds check out. So they are going to ask you to submit documentations about your qualifications so that you can prove that they are real, and the same about the absence of the exclusion grounds, but I will cover the exclusion grounds and also the abnormally low tender a bit later. What you know when the contracting authority asks questions, it doesn't mean that when they ask questions that they can also take the information you provide in your answers into account, and that it definitely means that the contracting authority will make a positive decision about whatever is lacking or whatever the contracting authority is asking about. It is just the contracting authority doing its job and ensuring that they fully understand the situation. In case there's something missing in the tender documents, they can ask about it, but the answer you give, it doesn't mean that they can rely on it. And the reason for that is the contracting authority has to ensure that it treats all tenderers equally. And equality here means that every tenderer had the same amount of time to prepare for the tender submission, meaning that if you submit anything new after the tender submission deadline, then the contracting authority would have given you more time to prepare than for those who did it by the deadline that they were required to do it. So there are only exceptional cases where the contracting authority is able to take into account new information given after the tender submission deadline, but I will cover those also a bit later. About deadlines, when the contracting authority is asking questions, they derive from the law, and the tenderer is obliged to answer within 3 working days. And yes, the contracting authority is able to extend the deadline, but you should keep in mind that the questions arrive to you through the public procurement register, and the deadline is not dependent on when did you receive it in your email, meaning that if you receive an automated notification from the Estonian public procurement register that the contracting authority is asking for something, the deadline is already running, so that you would really have to go and check whether there are any annexes in the question that they do not come with the email to your email, and see what is exactly needed or how you should act. So of course, if you need an extension, it is really good if you can ask it right away, or if there's anything you don't understand about the contracting authority's question itself, then ask clarifications again right away. But if you ask for an extension, then please give also some reasons, or valid or good reasons why the extension is needed, because the law foresees that the contracting authority is allowed to extend the deadline. It doesn't also say by how much, so it's also upon the contracting authority's decision for how long they would agree to extend the deadline, but they can do it only with a valid or a good reason, meaning that if you just ask for extension that I just need more time and no justification given, then if the contracting authority is really strict, then they can say that I have received your extension application, but I'm not able to extend it because you haven't given me a reason to weigh on. And therefore make sure that if you ask for an extension, then there is a good reason for that also written down in your answer to the contracting authority. Another issue is how thoroughly you should answer the questions. That again seems like a low issue or a self-explanatory one, but what we see in practice is that contracting authorities are also human. They make mistakes in asking the questions, meaning that they word it too broadly, or they ask funny things, although you can understand that perhaps they actually want to know other things. So I will give you a rule of thumb and then explain based on our practice what are the rules good to follow, even though there are no strict rules in the law, or the contracting authority do not tell you that you should do it this way, but it's based on practical experience. First of all, you should answer as much in as much detail as the contracting authority has asked you. And what we see in practice really often happen is that the contracting authority has listed out several questions, or the questions has multiple parts in it, but the tenderer doesn't answer to all of those. So you have read the question, you have understood some broad meaning of what the contracting authority wants to know, but not every part of the question is answered. And why is it important? It's important because the contracting authority is not obliged to ask twice. So that if the contracting authority has given you the opportunity to explain something, to submit something, then you should take it seriously and do it in the ideal format, or in the ideal way already in the first time. Because we have seen kind contracting authorities who explain you the second time that yes, you submitted something, but it's lacking something else that was also required, please do it. but they are not obliged to do it. They are obliged to give you the opportunity to at least clarify once, and if not used, then they can go on and reject your offer or exclude you from the tender because the contracting authority is unable to make sure that what is stated in your public procurement offer holds true. So if they're unable to verify that the data is correct or that the conclusions is correct, then due to the lack of information, they can also reject the offer. Moving on to the initiation of an abnormally low price review. What is it that you would need to know in Estonian surroundings when you do business here? So as I said, that in case an abnormally low price review has been initiated, then the Estonian court practice is strict, saying that once the contracting authority has already initiated it, then they have to follow it through and also make a decision about it. So there are two outcomes when you are caught in such a review procedure. One is that they ask questions, you provide information, the contracting authority analyzes them, they make a decision saying that yes, we thought that this tender price is abnormally low, or we had the suspicion of it, but we verified it and it's not. And the reason for the tender price being in a way it is are the following. Or the second option that, or the second outcome that can happen if you provide your answers is that the contracting authority states that although you answered back and gave the data, they still see that the offer is with an abnormally low price. Or in case you do not answer the contracting authority at all or give just some information and the contracting authority is again not able to verify that the price is the way it is for some other reason, then they can also reject the tender because they're unable to control what you submitted as a price. So what does the contracting authority ask about the price usually? Again, you could divide these questions in two types. What we see in practice is they could ask you really broadly that please give reasons to your price because we have a suspicion that is low, and then you just have to start answering. And the other case is that when the contracting authority is really particular and asks you several questions about your tender price, saying also that why they think it is abnormally low, what is the reason for it, and also adding multiple questions about please provide a breakdown of your cost. What are the costs you regularly have if you operate in your field? And what is the profit margin that you have planned for this contract or in your offer, so that the contracting authority can verify that the price is not abnormally low. And usually when you also state that here are my costs, or this is my cost breakdown, and this is my profit margin that I have calculated for this contract. Sorry. In this case, the contracting authority can really see that there is some buffer that you can cover your cost in case the contract really gets more expensive than initially planned, or something happens there, or you haven't calculated correctly. Many tenderers do not wish to give out the profit margin, so seen it several times in practice, because they are afraid that the contracting authority will mistreat this business secret and publicize it to other tenderers or also to the general public. When you answer about your price, then you should also add or include an explanation that this constitutes as your business secret, even though the total sum of your offer is not a business secret, because the contracting authority has to evaluate it. I will explain this later, but still the price breakdown does constitute your business secret, because the way you compile your offer, or what are your costs, or what are the proportions of your costs, this is something that makes you competitive and therefore you can explain that the contracting authority needs to treat this information as a business secret and not publish it. Why does the contracting authority need this information? As I said, they need to make a decision. They have to justify the decision, whether they see that your price is abnormally low or not. And they have to give really good reasons how they have controlled that it is not abnormally low, and what are the other arguments justifying the price you have given. So the more you give information to the contracting authority, the more you help them to make a enlightened and informed decision about it, and then there is a reduced risk that when a competitor disputes the decision, they want to kick you out. Then in the control procedures in the Public Procurement Dispute Committee or in the court will see whether the contracting authority did initiate a review procedure and whether they gave sufficient and good reasons why they believe that the tender price is abnormally low or it isn't. So if you provide little information to help the contracting authority, then they are also not able to make the decision or write down good reasons for that. As next, we will discuss the issue that when you have submitted a tender and then there's something missing in your documentation. Again, then there can be two reasons generally why there is missing data in your procurement in your offer or in a tender bid. And in the first case, you don't have to worry, it's all good. In the second case, it could be actually really bad. So the first case is that in case the public procurement documentation specifically states that there is some piece of information, annexes, descriptions, technical information, CVs, or anything like this, that the contracting authority allows you to submit later when they are conducting the review procedure, then this is something that you don't have to submit already with the tender itself by the tender submission deadline. So you're good there. But please really see and make sure that there is such an exclusion somewhere in the procurement documents, meaning that in whatever part of the documents in the register or in the files annexed in the register that allow you to not submit something. And in this case, it is a missing document, but it's a legally missing document. And the other case is that when you forget to add something, and usually this is legally quite bad and not salvageable, but I will go through the exceptions where the contracting authorities have accepted additional documentation or data, and the courts have also accepted that it's okay for the contracting authority to rely on them. But as I said, these are rather exceptional cases, and as a general rule, the tenderer is obliged and responsible for submitting the tender, seeing that it is as requested by the procurement documents, so that you go through one by one and check that everything that the contracting authority has asked you to provide, you have provided. So this is the main obligation of the tenderer, and in case you make human errors, they usually are not salvageable, and it means that your tender is rejected due to the fact that it doesn't comply with the tender documentation or tender requirements. So what are the cases when there is something missing, but the contracting authority is able to ask questions about it or ask you to submit the new documentation and still rely on it in the later stages where it makes decisions based on these data? So as I said, if anything is missing, you are able to say that it's a human error, which they usually are. Meaning that there is something, let's say a typo in the documents where you wanted to describe the experience of a specialist, wanted to describe their employment experience, stating that from this year to this year they worked as somewhere or on that project, and you have made a mistake in the number of the year. So this could be regarded as something that the contracting can see as a mistake in the procurement documents or in the offer. And they can ask you about it, and then you can prove that yes, based on the person's CV, you did type it in wrong, but the actual experience is from this year to this year, and the contracting authority is exceptionally allowed to rely on this information because the experience of the person was there already before the tender submission deadline, so that the person did not get this experience after the tender submission deadline. But in case there is a mistake in the procurement documents, like something does not open in the format that the contracting authority has asked you to submit, or there is an annex or documents or technical description is missing at all from the procurement offer. In this case, this is not a mistake, and the contracting authority, or it is a mistake looking at it from your side, but the contracting authority, they can see that everything is linear in the procurement offer. That yes, they see that is missing, but that there is no obvious confusion in the data, and therefore there's nothing to explain, or there's nothing that they can ask for you to explain. Again, in very exceptional cases, the courts have allowed the tenderer to submit new evidence about the tender in the later stages of the procedure, meaning that after the tender submission deadline, in case the documentation proves that the requirement that you're trying to prove additionally was also achieved or attained before the tender submission deadline. For example, if the tender documents require that you run a test on the software or the equipment that you are offering, and you were supposed to prove that the test has been run before the tender submission deadline, but you forgot to add the confirmation or the report proving that you did it before and you did run it before, then in case that document shows that the date of the report is earlier than the tender submission deadline, they might accept it because you did not gain any new advantages from the added time that is between the tender submission deadline and you submitting new documents when the contracting authority is asking you about it in later stages. So as I explained earlier, the contracting authority has to make sure that all tenderers are treated equally. This also means that when there's a tender submission deadline, everybody has same chances, same opportunities to draft it, submit it, and compile it in the right way within the same time frame. And if someone gets new opportunities later on, then this is discriminatory. So in case of this past example about running the test on your equipment, in case you submit a document that the test has been run after the tender submission deadline, then it's quite clear that your procurement offer did not comply with the tender requirements when you submitted it, because one of the premises or one of the conditions was filled later on after the tender submission deadline. Moving on to the exclusion grounds and proving that there is none. Again, a practical experience shows that companies coming to Estonia from foreign countries, they are sometimes even shocked or at least surprised that the contracting authority asks you about the names of the physical persons who are, for example, in the company's supervisory board or in the management and so on, who can control the company and who can make decisions for the company. The Estonian law requires the contracting authority to check the absence of the exclusion grounds for all of these people, so that the contracting authority needs to be aware who are the people on the supervisory council or in the management team who then have to be checked, or whose criminal records have to be checked. And the way they are checked is that you need to submit criminal records extracts or reports that are issued in your country for each of those individuals. And as I said earlier, the deadline usually is 3 days or 3 working days to submit this documentation. So it makes sense that once you already have submitted your offer, then you should start preparing or start gathering the extracts from the criminal records, and also about the tax arrears of the company in general, so that the contracting authority will ask you about them and will ask you to submit them if you are a successful tenderer, because they are obliged to do it. So they cannot leave it unchecked, even though you say that in our country it is highly unusual to submit any documentation or give out the names. So it could mean that if you do not provide this, that you will be excluded. In case your country doesn't have the same type of extracts or reports or proof that the contracting authority is asking about, the exclusion grounds, meaning the absence of criminal records, or that there are no tax arrears in your country, then explain to the contracting authority what are the available means for you to prove it. So how the system is different, so that the contracting authority understands what is the reason you're unable to submit the exact documentation that the contracting authority is asking, and then provide the documentation you can. For example, self-declarations are allowed in case you have explained that in our country this type of documentation is not given out, or it's only given out once per year, so we don't have a newer one. And we have also advised, and also our clients have submitted notarized self-declarations about the absence of the criminal records or other data that the company is unable to prove the way it is done in Estonia. For example, in Estonia, you can go into the public procurement register as a contracting authority, push a button, and the public procurement register is linked with the criminal records and also with the database showing tax arrears. So it's super easy in Estonia to do that, but we know that it's not the case in every country. So you would need to explain to the contracting authority what is the system in your country and what are the available evidence that you can provide, and then also provide them. And if there's additional time needed for submitting it, because as I said, 3 working days is the initial deadline, or 5 working days is the initial deadline given by the contracting authority, ask the extensions well in advance. About what's public and what's not public regarding Estonian public procurement, what is the information that is available for the general public and also available for the other tenderers in the public procurement. So as in all other European countries, public procurement information is public, meaning that you can go into the public procurement register in Estonia and check out every procurement that every contracting authority has published. You can also see the documentations, they are publicly available. But when you are the company to submit an offer, the general public does not see that. So when you have submitted your tender, then the contracting authority is obliged to make a protocol after the tender submission deadline. So actually the register is doing it for them. And the companies within the same public procurement procedure, they can know who are the other companies who submitted the bid and what else is public within the public procurement procedure for every other company to see the numerical values that the contracting authority has to evaluate later, like the tender total price or whatever tender price parts that the contracting authority later on has to evaluate and what make the successful bidder. So this is something that every other contestant is able to see and is able to ask the contracting authority to publish them. But about the tender offer itself, if we're talking about the technical offer, first of all, you are obliged to submit information in the tender explaining whether you have a business secret there, or if you do, what is it and why do you think it's a business secret. It's actually something that you cannot miss in Estonian Public Procurement Register, because there is an extra field for that, asking you that does your tender include any business secret, and you have to answer yes or no. And there's a bracket after that where you can then add explanations if you press yes, stating that, for example, part of my qualifications are a business secret because they are based on confidential agreements, and if the contracting authority wants to know them, we have to ask the client or the end client to allow us to give this information to you. Or my technical offer is a business secret because this data is not publicly otherwise available. Therefore, it constitutes my competitive advantage in comparison to my competitors. So there has to be at least some type of confirmation or explanation about what is secret, and also why it is secret. And I will explain you a bit later what happens if you don't. The general public will see who was the winner and what's the tender price after the contract has been signed. So the general public does not receive information about who have submitted the bids during the public procurement procedure. And they do not receive the substantial offers as well. If you forget to mark down the business secret, in practice it would mean that the contracting authority is by law allowed to publish or give out the successful tender's offer in full, because the successful tender is considered public information as per the Estonian Public Procurement Act. In reality, the contracting authority, contracting authorities, they are hesitant in giving out the information about any public procurement offers, because they fear that this might contain public business secrets. And what usually happens is that when someone is asking about whatever offer in substance, they're asking it to send it to them, the contracting authority usually turns to the tenderer asking that, I have been approached with a question to publicize your offer. May I do it? Or if there is any business secret, please let me know what it is, so that in case you have forgot or you haven't submitted information about your business secret, in practice, most of the contracting authorities still ask about it. But for every other tenderer who was not the successful tenderer, by law, those tenders in substance, they are not public, and therefore they are also not publicized. But as I said, it's not only the technical offer that usually is secret, or there's something secret about it, or the price breakdown that is secret. You can also have qualifications that could be secret, so that keep in mind that it's not only the technical part that you might wish to cover up, but also some parts of the qualifications. But the qualifications in essence are not regarded as confidential, so for any other tenderer as well, meaning that if there is a dispute over the qualification criteria or qualifications that someone has submitted, then the contracting authority will give those out to the Public Procurement Dispute Committee and to the court, and it's up to you to say in advance if they're confidential. We usually get also questions about what are the time limits from the foreign countries, that if I come to Estonian public procurements, what do I have to consider with? And the short answer is that there are no deadlines fixed in the law, either for the procurement procedure itself, nor for reviewing the tender bids, so that these are all open. What I can say in practice about the Estonian procedure is that if it's an open procedure, it as a minimum lasts for 4 to 6 months. It can also take longer. It depends on the volume of the documents and the volume of the tender bids, and usually checking the conformity of the tender bids is the slowest procedure, but that can take long. And as I explained, in case there is a successful tenderer, the contracting authority has to check the absence of the exclusion grounds, meaning that the whole dance about who is your supervisory board member and please submit excerpts from the criminal records that they do not have criminal records. This has to be done also within that time. In case it's a negotiated procedure, we have also seen some procurements last up to 1.5 years, where you have this application phase and qualification phase as first, and thereafter you have negotiations and the evaluation of the tender bids conformity and the successfulness of them. So this can be a really long procedure. Why this is important? It's important that if you make a price offer, then you know the average or the normal time frames that you have to be tied with the offer, meaning that you really do have to take into account that the price you offer out, you would be able and willing to execute the contract with that price also in a year, so that if you make the profit margin really small, and for example the construction prices or the steel price or the wood price changes a lot, so this could mean that you're not motivated anymore to really execute the offer you would like to get out of it. But in case you withdraw your tender and you are the successful tenderer already, this means that the contracting authority is allowed to ask you to compensate the damages, and the damages mean that this is the tender price difference between your tender price, the successful one, and the one that's the next after you. So the Estonian Public Procurement Act specifically states that in case a successful tenderer withdraws, is not willing to go into the contract or is not willing to sign it during the time given by the contracting authority, then what can follow is a damage claim. Regarding the signing of the contract, as in other European countries or as stipulated in the European public procurement directives, there's a standstill period, usually it's 14 days. And in practice, Estonian contracting authorities initiate the signing procedure right after it. So there is not a wide time gap after the standstill period and signing the contract. Usually we see that it happens quite fast. If it doesn't, just write to the contracting authority through the public procurement register and ask about it, that the 14 days after the last decision made in the procurement is made, then when do you plan to sign the contract, so that you will just get the information and know what is happening. And again, usually the contracting authorities reply nicely and you can have the information. And as a last topic, a bit about the decisions that the contracting authority takes during the procedure. There are multiple different kinds of decisions that the contracting authority can and is obliged to take. It really depends on whether the procedure is running normally or there are some peculiarities that separate the decisions need to be taken. So that the usual way, let's say the two patterns, how the decisions are can be made based on the Estonian Public Procurement Act and based on how it's done in practice. As I said, there are two patterns. The usual way that is not widely used anymore in Estonia, but still this is how the law sees, is that once you have submitted your tender, then they are going to first see whether you have any exclusion grounds, therefore asking you to submit the documentation about the absence of them. Then they're going to check the qualifications, thereafter the conformity of the technical bid, and then they're going to evaluate the tenders and see who is successful, and then again control the absence of the exclusion grounds for the successful tenderer. As I said, this is not so widely used anymore in Estonia because the law allows the contracting authority to use the so-called reversed decision making, which means that the contracting authority checks the absence of the exclusion grounds and the conformity of the qualifications based on the ESPD, the European Single Procurement Document. This is this has different formats in different countries, but in Estonia, this is built-in the public procurement register. So if you're making your offer through the register, and this is the only way you can make it, you will have been filled it out. So you have it already where the confirmations about the exclusion grounds and the information about the qualification is asked. So they will make the first decisions based on this data. They will not ask for any substantial new evidence. And then they will check the conformity of the technical bids. If needed, they will ask for additional information, check the suspicion on the abnormally low price. And once they have done that, they are making the decision about the successful tender, meaning that they are evaluating the tenders and publishing this type of decision. And then again, only for the successful tenderer, they are asking to submit the proof for the qualification and the proof for the absence of the exclusion grounds. So it's a bit easier, and usually goes also faster, that the first checks are done based on the ESPD, and then the substantial conformity is only checked for every tenderer for the technical bid, and thereafter the exclusion grounds and qualifications substantially only for the successful tenderer. And as I said, after the last decision has been made, that there is a standstill period, and in case of the reverse decision making, the last decision is not evaluation decision declaring the winner, but the last decision is the controlling of the absence of the exclusion grounds. So there are different models. And the contracting authority is also allowed to batch the decisions, meaning that they don't have to give out the decisions one by one, but they can make all those decisions together and then send it out to the tenderers. The only decision that they cannot batch are the last two decisions in the reverse decision making, and they are the checking of the qualifications in substance and also the absence of the exclusion grounds, that these can only be checked after the successful tenderer has been chosen, because the law foresees that checks for the successful tenderer, not every other tenderer. The contracting authority is obliged to give reasons in case they see that something is not in conformity with the public procurement documents, so when they reject your tender, and also in case of abnormally low tenders. If it is a positive decision saying that this technical bid is in conformity with the public procurement conditions, then they don't have to substantiate it, but in most of the cases they do at least have to give some justifications. The time limits for informing the decisions are 3 days or 3 working days after they have done it, and the way you receive the decisions is through the public procurement register. Again, the notification comes to your email, and this also marks the time when the disputing deadline has started to move, so that don't ignore those messages. If you want to, or if you would like to consider at least disputing those, then you would have to see the decisions right away. And the contracting authority is not obliged to send you the full formatted decision, but they can give you also the information about the decision and the main reasons in the electronic way, so that they just give you or send you the notification that the decision have been made, the decision is like this, and these are the main reasons, and these also constitute for the tender the opportunity to evaluate whether they would like to go on and dispute it or not. So do not wait for a really pretty decision to arrive in your email box. And this is it from my side. Thank you.
You are watching Sorainen Public Procurement Academy. Stay tuned.